Hi, everybody. Thanks. I'm really honored to be here and proud of this group of people, you people, for doing the work that you're doing. I've worked with the District of Utah now for several years, starting, I guess, now back in 2010 or 2011, specifically on what we call district-wide reentry planning, which treats the entire federal district, which is great because it's the entire state, as the organization and brings together the stakeholders in federal criminal justice. And so it's great to have you all who work with state and local criminal justice agencies here as well, because very much that's where the rubber hits the road, and so important to have collaboration between state, local, and federal criminal justice stakeholders. Can I get a sense of folks, basically who's in the room? Probation and parole. Can I just get a show of hands? Okay, thank you. Prosecutors. Okay, defenders. Great. Treatment providers. Okay, judges. Okay. Law enforcement, other than probation and parole. Okay, great. What else did I miss? Who did I miss? Yeah, Corrections, Department of Corrections. Thank you, sorry. Great. Anybody from the BOP? Okay, halfway houses. Excellent, cool. All right. Disability Law Center, awesome. Great. And various and sundry other folks who, players to be traded later. Thank you all for being here. Fantastic interdisciplinary group of people in the audience. So I'm Mark Sherman. I work at the Federal Judicial Center. It's the education and research agency of the federal courts, if you don't know it. It's a very small agency. And I manage a small group in this very small agency that works with probation, pretrial, judges, defenders, and increasingly prosecutors and treatment providers on issues of community supervision, pretrial issues, et cetera. So my assignment today was to provide an overview of risk assessment in U.S. Probation and Pretrial Services. Debbie and Gordon and Beth have laid the foundation perfectly. And so I'm going to be sharing the floor with Meriska Holt, who's a U.S. probation officer here in the District of Utah. She's going to talk more specifically and very practically about how post-conviction risk assessment works in the federal system here. One of the things that I wanted to say, as whenever I hear these kinds of presentations, I'm struck by how intimidating they are, right? It's just, for some of us, it's like a foreign language. I'm not trained as a behavioralist. I'm a lawyer. I've had to learn all this stuff on the fly by coming to presentations like this from probation officers and really skilled people who are out there in the field doing the work. I happen to live with a clinical social worker, and that helps immensely. And the free therapy is terrific. Her rates are reasonable. So I'm very fortunate because I can talk about these things with her. It's intimidating. And so none of us should come to this. I think we all need to come to it very humbly, right? And that none of us really is doing it particularly well. Right? I can say that for those of us in the federal system because this is all pretty new for the federal system, okay, for federal probation and pretrial for the federal courts. Not even 10 years old, right? So very much still in its infancy, right? And it's going to take many years for us to learn how to do this stuff well. So Debbie, her presentation, criminogenic factors, dynamic risk factors, whatever you want to call them, static factors. This stuff is very intimidating. It's hard to learn. It's hard to master how to do well, right? And it's going to take time. And we just need to be really purposeful about it. And we will get good at it because we're smart, right? But we have to work together and be patient, but not too patient. So I would say that the way we're doing it in the federal system in terms of how well, and anecdotally, and I get to work with all 94 federal districts, right? It's very spotty, as it should be, because this is a learning experience for us. So we're getting better at it. So very quickly, an overview of risk assessment in the U.S. Probation and Pretrial Services system. So as you've heard, it's a critical component of evidence-based practice. Risk and needs assessment identifies, as Debbie just talked about, which persons to target for correctional interventions, what characteristics or needs to address, how to deliver supervision and treatment in a way that optimizes positive outcomes. So this is all review for you at this point. Post-conviction risk assessment instrument. So I'm going to go backwards and talk about the post-conviction risk assessment instrument first, and then the pretrial risk assessment instrument. The PCRA, as we like to call it, was developed by the Administrative Office of the U.S. Courts Probation and Pretrial Services Office, 2009-2010. It includes both static and dynamic risk factors most associated with recidivism. It allows for reassessment, right? Directly informs the supervision and treatment plan. It was validated using PACS, that's the Probation Automated Case Tracking System in the federal system. PACS data, existing risk assessments from 5 federal districts. They were experimental districts that were using the off-the-shelf products that Debbie was just talking about, not the LSIR. They were using the Compass and they were using the RMS. Those are 2 off-the-shelf commercial products. Those are 3rd-generation risk assessment instruments, which basically means they include static and dynamic risk factors, but they don't inform the case plan, or they weren't created to be part of a case management plan. That's the difference between what they call the 4th-generation risk assessment instrument and a 3rd-generation risk assessment instrument. The 4th generation, which this newer post-conviction risk assessment is specifically designed to work with a case management plan. All right, and the federal system, like I said, we're just getting up and running with that, sort of figuring out how to do a case management plan with the risk assessment instrument. So that's the difference. Validated using those 5 experimental risk assessments from those 5 experimental districts, criminal history records, and pre-sentence reports. There were 2 validation samples. That's actually the 193,586 individuals that the instrument was validated on. That's just the 2nd sample, right? The first sample was another 50,000 people. So it's been validated on a lot of folks. The PCRA consists of 2 sections, an officer assessment and the offender self-assessment. It consists of scored items and unscored items. The scored items are statistically significant predictors of recidivism. Debbie just went over them in her presentation, so I won't bore you with them. Unscored items are possible predictors, but first need to be studied on the federal population before being used to determine risk level. And again, just think about risk assessments as constantly being updated and revised. Okay, it's not something that we're going to be using for the next, as it stands now, not the assessment instrument we're going to be using in sort of a static way for the next 10 years. It's going to be revised constantly and revalidated constantly to make sure that it's accurately predicting risk. So moving right along. The scored and unscored items are included under several domains, and 7 domains: criminal history, education and employment, substance abuse, social networks, cognitions, other, meaning housing, finances, recreation, et cetera, and responsivity factors, which again, Debbie talked about in her presentation. So the offender self-assessment, which is kind of, it's all interesting, but the offender self-assessment particularly interesting, and it's based on the psychological inventory of criminal thinking styles, or the PICTS, that was developed by Glenn Walters of the Bureau of Prisons. And it assesses 8 criminal thinking styles. So, and these 8 styles are mollification, cutoff, entitlement, power orientation, sentimentality, super optimism, cognitive indolence, and discontinuity. Just for example, mollification is basically blaming external factors for your criminal behavior. Cutoff is basically sort of emotionally cutting yourself off from the criminal behavior and just sort of going for it. Sort of thinking about the consequences, but then not thinking about them and just sort of being impulsive and going for it. Entitlement, right? That's the, so everybody in this room has engaged in criminal thinking, okay? Everybody. That's what Debbie was getting at when she was asking you who broke the speed limit, right? So it's just a continuum, right? We deal with the worst criminal thinkers, right, in the criminal justice system, but we all do it, right? So entitlement, we all do that, right? Hey, I have to get to the office. That guy's breaking the speed limit. I can break the speed limit too, darn it. Right? Entitlement. I'm allowed to do that, and I'm going to get that thing no matter what, because that person has it. And if that person has it, it's okay for me too. Power orientation, sentimentality, super optimism, the list goes on and on. I wanted to say, because I'm moving quickly through this, that this presentation is derived from 2 papers that are publicly available. And I wanted to just let you know about that in case, you're really a geek and you want to get into this more deeply, right? But seriously, the papers are both really helpful primers on federal risk assessment. One is at uscourts.gov. When you go to the uscourts.gov website, you'll see a menu item for probation and pretrial services. Just click on that menu item, and then on the left menu, it'll say supervision. Click on supervision, and you'll be able to access the paper that this was derived from. It's basically just a paper on post-conviction risk assessment. The other paper, if you Google it, it's publicly available. It's basically federal pretrial risk assessment, and it's a paper that was sponsored by the Office of the Federal Detention Trustee, which is now within the Marshal Service, and the Administrative Office of the U.S. Courts. Both papers publicly available. If you want to email me at msherman@fjc.gov, I can send you the links. So moving quickly. Oops, what did I do? Okay. So the PICTS results in 3 scores: general criminal thinking, proactive criminal thinking, which means planned criminal thinking. That's really sort of where you're getting at sort of the sociopathy, the psychopathy, the antisocial personality disorder stuff, and the reactive criminal thinking, which is everybody else, right, reacting to a situation. Then the total risk score is calculated, and the total score falls into one of 4 risk categories, important to know: low, low moderate, moderate, and high, right? So what we're trying to do in the federal system is target the moderate and high folks, right? Some of the low moderates as well in terms of providing services. There are overrides as well with the post-conviction risk assessment instrument. So this is one of the things that I think people, professionals and others, sort of think about when we're talking about risk assessment, because sometimes we think about things in an all-or-nothing way, and that is really important. It's a really important thing not to do that, okay? So yes, when you do a risk assessment, it should govern. Generally, the results should govern what you're going to do in terms of case planning and working with the individual under supervision. However, there can be exceptions based on one's professional judgment, right? That's number 2, professional overrides. So overriding what the PCRA is telling you as the officer, the supervision officer, right? And then in the federal system, there are policy overrides. Sex offenders tend to score low on the PCRA. And obviously, that's an issue. So we need to treat them a little bit differently. Persistently violent offenders, those with severe mental illness, youthful offenders with significant criminal histories, etc. And the most important thing, especially when you're working within a probation environment in the federal system, is that both overrides require a supervisor's approval. They need to remain the exception and not the rule, not become the rule. Okay? But I do think it's important for us to recognize that professional judgment matters, right? Professional judgment matters. When you go to a doctor, right, and the doctor orders tests, right, and the tests come back, right, and certain things are showing up on the test results, right, the doctor is not, hopefully, your doctor is not going to blindly follow the results of the tests, right? But they're going to look at the test results critically, and within their experience and professional judgment, if the test results make sense, they will diagnose accordingly and treat accordingly, right? But if the test results don't make sense, hopefully the doctor will say, there's something wrong here. We need to do more tests, or I need to investigate this further, right? That is the model, right? It's that latter model. You've got to sort of look at these results critically, and if they are making sense to you, you follow them. If they're not making sense to you, you got to do more work. So I just wanted to address that because I've had so many conversations with prosecutors, defenders, probation officers, you name it, about The fear of risk assessment, because then it's like, what happens to professional judgment? It's still there. You still use it. So the outputs for the PCRA: total risk score, risk category, criminogenic needs, the dynamic risk factors that Debbie was referring to be targeted in the case plan, right? And then responsivity factors. Again, she referred to that as well. Those factors that can present barriers to supervision and service delivery process, targeting those responsivity factors and dealing with them so that the person does well in treatment. Pretrial risk assessment, the PTRA, right? We've got the PCRA and the PTRA, okay? The PTRA was developed by, again, the U.S. Administrative Office of the U.S. Courts Probation and Pretrial Services Office staff, approximately 2009, 2010, going into 2011, using data collected through PACTs. It's an objective quantifiable instrument that provides a consistent and valid method of predicting risk of failure to appear, new criminal arrest, and technical violations. So pretrial, so much different than post-conviction. It's comprised of 11 scored items divided into 2 domains, criminal history and other. Criminal history items are static. Remember, we talked about static and dynamic risk factors. They will not likely change during the pretrial period. Other items are changeable and might slow, so dynamic, right? Other items are changeable and might show movement based on pretrial supervision and services. So these are the things we want to focus on if the person is released with conditions. Scored items are assigned points, either 0, 1, or 2. And the points are added up to give an overall score. It provides a score that allows for classification into a risk category. Again, similar to the PCRA, but it sounds a little bit different. Those risk categories are then associated with rates of failure to appear and CA&TVs. The criminal history items. Number of felony convictions. This stuff will sound familiar to you. Prior failures to appear, pending felonies or misdemeanors, current offense type, offense class, age at interview. Pretrial risk assessment, other items. Highest education, these are the dynamic things. Highest education, employment, residence, current drug problems, current alcohol problems, citizenship status, foreign ties. And here are the outputs. Total risk scores determined by adding up all the points for each of the scored items. The scores range from 0 to 14, and the categories are as such. So we're not sort of categorizing specifically in terms of low, low, moderate, but it's categories. 0 to 4, category 1, 5 to 6, 2, 7 to 8, category 3, 9 to 10, category 4, and 11 plus, category 5. And that's it for the risk assessment instruments. Before I switch gears and turn it over to Meriska, questions about the post-conviction or pretrial risk assessment instruments? Yeah.
I guess quickly, just the difference, because one of the things that the state of Utah is looking at is a pre-screen to tell risk levels of offenders that have already been convicted versus, when you're talking about a pre-trial, their failure to appear or to appear assessment. Can you talk about just the difference in those two? Unless you're saying that the pre-trial assessment would be a good pre-screen before a full PCRA would be done.
So, the way that it works in the federal system, or we're hoping will work in the federal system, that's more accurate, is that because not all districts yet are using the pretrial risk assessment instrument, that is where we're heading. So the idea is, on the pretrial side, the statistics indicate in the federal system that we're detaining a lot of low-risk people, right? So the purpose of the pretrial risk assessment instrument is to really give us a good sense of who's low, who's high, and what the dynamic risk factors are, and who should be getting services, right? Because the idea is if we don't need to detain low-risk people, we shouldn't be, right? And so ideally, now, most of the people who enter our system end up going into the BOP, right, and then coming out to a halfway house and on to post-conviction supervision. Ideally, right, when the system is working well, when it's going to work the way it's supposed to work, right, on the post-conviction side, on the back end of things, we'll have access to the information from the front end, right? And hopefully, and certainly, the BOP should have that information in the pre-sentence report, right? So that they will be able, through the way that they do risk assessment, classification, and designation, that they'll be able to classify and designate the person appropriately so that they have access to the types of programs that will address their dynamic risk factors as well. So that we're not starting from scratch on the back end. So that's where we would like to go. It's aspirational, but some districts are beginning that process and are sort of on the way. So, yeah. Judge Adams.
It may be useful to know that in this district, the percentage of people on pretrial release who fail to appear is 0.6%, less than 1%. The percentage of people who are rearrested on pretrial release is 3.8%, so less than 4%. Mm-hmm. It's also, I think, helpful to understand that if you obtain pretrial, your sentence is 3 to 6 times likely to be longer than if you're on pretrial release.
It's a great point, all of those. And I think it's also one of the things we've seen through the research, at least in the federal system, is that people who are released on pretrial supervision tend to do better on post-conviction supervision. So all of this is a good argument in favor of doing this kind of risk assessment on the front end and on the back end, as well as sort of sharing the information with the BOP through the pre-sentence report so that folks can be designated and classified appropriately when they're in the BOP. Other questions? Yeah.
One other thing, slightly off this, but
sure.
I'm curious, as you mentioned, shifting services from low-risk offenders toward moderate and high. Could you just briefly describe what supervision for low-risk offenders looked like before and where it's heading?
Right. So it was all over the place. This is the problem, is that it was very anecdotal, right? To the extent risk assessments were used in the federal pretrial system, right? They were used sporadically. We did have the second generation. I guess it's a second generation instrument. We kind of skipped the third generation in the federal system, went directly to the fourth generation. The second generation instrument that we were using for many years is called the Risk Protection Index, right? Developed by the research division of my agency. And it was only static risk factors and a very good predictor of risk. And that was primarily, for many years, just used exclusively on the post-conviction side. Several years ago, before we got into the development of the new instrument, a pretrial RPI, Risk Prediction Index, was developed. It was used sporadically. Again, it consisted only of static factors. Most districts didn't use it, right? And so what was happening was that people on who were low risk, who were on supervision, often were being over-supervised, right? Either with services they didn't need or being over-supervised by a pretrial services officer, right? Which has a tendency to trip people up, right? And that's why you see people who are over-supervised, who are low risk, doing worse on supervision than people who are high risk, who are getting services. And I think either Beth or Debbie referred to those kinds of statistics. So what's positive about the direction we're heading now is that it's less anecdotal, it's less sporadic, right? And it's much more systematic, right? And scientific. And I think that's really what we all kind of need to, and this is kind of what makes it intimidating, because there's a criminology piece of this, there's a social science piece of this, and there, frankly, is a neuroscience piece of this, right? And that can be very intimidating because we're having to learn the language of science. But it's going to make the work that we do more meaningful and satisfying, and is going to inure greatly to the benefit of communities and to individuals. So that's kind of how it was working before, and as versus how we'd like to work in the future and now. Anything else? All right, let me turn it over to Meriska Holt.
So what I wanted to do with the PCRA is kind of give you a before and after experience with my supervision caseload. And for those that don't know me, I'm Meriska Holt, and I supervise a post-conviction supervision caseload. I work primarily with the mentally ill offenders, but the example I want to share is one of the mainstream cases that I supervise. quick background on me. I have a background in social work, a previous clinician, and so I have a history of doing mental health assessments, using risk assessments. So when the PCRA came about, I totally understood the need for it. I understood why other officers would need the PCRA, but I had my own way of doing things. But I'm a rule follower. I'll definitely use the PCRA, but I had my way of doing things, and I was just going to keep going on with how I usually do it. So this was a really good example for me and why I changed my whole opinion on the PCRA. So my example is Ryan. Ryan is a 37-year-old man. He was charged with Hobbs Act robbery. He had a huge addiction to opiates and heroin. He was robbing stores for money, and then it eventually turned into robbing pharmacies for actual pills. He served 48 months in the Bureau of Prisons, and when he sat down in front of me, he was going to serve 36 months of supervised release. So what I normally do with people is go over their conditions of release, and then that's when I start my risk assessment. So what I usually do is go over typical barriers that all of our offenders struggle with, and the first is housing. Ryan lives with his parents on the East Bench in the Cove, beautiful pool in the background. I even think there's a dog that runs in the background. So perfect situation, because as a lot of us know, housing is a huge barrier for our people. The second thing, social networks. As I said, Ryan lives with his parents, grew up in an intact family. He hadn't burned any bridges with them, and all of his siblings still supported him, and they were a close, tight-knit family. So check that off. Employment. Prior to being incarcerated, Ryan was in sales, and he felt confident that he would be able to either go back to his previous job or find something else. And so we verbally contracted that we would give him 30 days to find a job, and if he wasn't able to secure something, I could refer him to our DOWD program. So once again, we're just cruising along down these barriers. Next one's financial. Ryan was debt-free. He didn't owe any restitution, so he didn't have that pressure over his head that he had to worry about money. Next is education. He's a high school graduate. We talked about this earlier. He has a couple years of college under his belt, and he was really articulate, which is probably why he did well in sales. So that, again, was another barrier that I didn't need to worry about. And second to last is health. He was in great health, wasn't on any medication, so I didn't have to worry about him not having access to doctors, physicians, or medication. And the last thing, which was going to increase his risk, was his history of substance abuse. As said, he had a severe addiction to opiates, but he had been drug-free for 4 years. Yes, it was with the assistance of incarceration, but he took full advantage of his time in the BOP, and he participated in what we call an RDAP program, which is a residential treatment program. And they do over 500 hours of programming. And even after that, when they come to our halfway house, they're still programming, and he completed Odyssey House. So when I brought up treatment with him, he was a little bit resistant. He said, I am programmed out. I feel confident that I'm going to be okay with that. So I contracted with him. I said, okay, let's put you on drug testing, and we'll watch it. And you promise me that if you're struggling at all, come to me, and we'll get you some help. So in my head, I'm thinking, this is going to be easy. I need an easy case. Because as I said, I supervise primarily the mentally ill offenders, and they are and can be handfuls. They're very difficult to supervise. They take up a lot of time. So I needed a Ryan to balance out that caseload. I thought this is going to be an easy person to supervise. And I was way wrong. But we'll get to that. So I needed to make sure, like I said, I'm a rule follower. I needed to make sure that my assessment of him, I had an idea where I was in line with the PCRA. So he fills out his portion, I fill out my portion, and he leaves, and I punch all the information into the system, and it came out low moderate. And I'm just thinking, voila, that's exactly where I would have put him. So there's more information that comes out with the PCRA, but remember, I'm a little cocky, and I thought, I know what I'm doing here. So I just file the PCRA away, and we go forward with his supervision. So A couple months go by, and Ryan calls me. It's about fall time. And he says, I went to the University of Utah game, and I used cocaine. So as a previous clinician, and statistics show that it's not unheard of that they're going to have a lapse. So because he was honest and he contacted me, I didn't catch him. I wanted to work with him. So I said, all right, Ryan, let's get you into some treatment. Again, he was resistant because he's like, I am so treatment out after all that programming in prison and in the halfway house. But after some pressure and coaching, he agreed to do it. Let's see. So get him into treatment. After a couple weeks, too, all of a sudden, Ryan stops checking in. And our check-in system in the federal system is pretty easy, pretty lax. We have a couple options. You fill out a piece of paper, mail it in, fax it in, bring it in person. And we've actually even started getting away from that, where you can go online, press enter, and done. So you can do this from the privacy of your own home. So for him not to report is pretty dang irresponsible, lazy. So I try to contact him by phone, by text, something we've done previously, and he'd been right on it, but he's not returning my phone calls. So obviously I have to go to his house and find out what's going on. So do a quick home visit. Dad's home and says, he's doing great. He secured this amazing job. He's making really good money, and there's no problems whatsoever. I'm surprised you haven't heard from him. So I tell Dad to have him call me, go about our business. More weeks go by. Then I start getting missed drug tests. Then I start getting missed treatment. So again, I have to go back to the residence because Ryan's not answering my phone calls. And Dad says again, no, he's doing even better. He's working overtime. In fact, he's making so much money now that he's got this brand new Audi. And that's when I really get upset, because I'm thinking, I really hate it when my people drive better cars than me. But then I know that the only person who has a worse car than me is Judge Warner. I don't know if he's here. So that's the only saving grace that I have for that. But anyway, so, Dad, please have him call me. But what's frustrating is, in the back of my mind, literally months have gone by, and it's like, I can't keep letting this, I have to do something. So he's still not calling me. So I finally get to the point where I'm like, Ryan, if I don't see you in my office tomorrow, I'm going to go forward with a formal violation. So who comes into my office the next morning but Ryan? So we sit down, and I think it helps when you put things in writing. So all these dates are in front of him of all these missed tests and treatment, and he's completely just blown away. He's like, wow, I'm doing better than I ever have in my whole life. This is the best I've ever done. I'm not using drugs. I'm not, hanging around with the wrong people. And I'm like, Brian, I have no idea you're not using drugs because you're not going to treatment and you're not testing. So we do what's called an administrative staffing, and he agrees in writing to a control and correctional intervention. And instead of a formal violation, he just agrees to, A, continue with his treatment and drug testing, and B, to come in to the office every Monday for an indeterminate period of time. And then in that contract, it states if you have any future violations, that this will be realleged formally in the future in a petition. So Ryan leaves. I think this is like on a Thursday, Wednesday or Thursday. So the first Monday comes around, and does Ryan show up in my office in person? No. And I'm just like, are you kidding me? So then the enabling mother in me thinks, well, maybe he didn't know it was this Monday. Maybe it's him next Monday. So I give him the benefit of the doubt, and the next Monday comes, and Ryan doesn't show up. So I do the whole thing over again. Where are you? What's going on? Remember that contract that you signed? And he tells me about a flat tire, and his sister had to move, and just all this nonsense. And so at this point, I'm done. I'm just done. So I get a petition. I get a petition for a warrant, and he actually turned himself in. But I'll never forget, in front of my peers and in front of the judge, in an open courtroom. He stood before Judge Wells. I don't know if she'll remember this. But he says, I just didn't take my supervision seriously. It was not a priority to me. And I was so frickin' pissed. Because Trina Higgins was covering that, and she kind of like looked back at me after, there was like 15 allegations at this point. And I think Judge Wells was just like, what the hell? You let this go on this long? But, you know, not only did he have a job, he had a career. And we all know, especially the people from the Dowd program, it's so hard for these people to get a job, let alone a career. And I wanted him to not lose that opportunity, but enough's enough, right? So he gets formally sentenced, does his time, gets out. He's sitting back in front of me. Here we go again. Go over the conditions of release. He does his PCRA. I do my PCRA. But this time I decided to do something different. I actually read the results. So it still was low moderate, but I went to the bottom and got some details on Ryan. And what it specifically said is elevated criminal thinking styles. He's a criminal, of course. But Mark had pointed out the 8 thinking styles, and specifically to Ryan were 3. And the first was the cutoff. And it's a measure of impulsivity and the tendency to use phrases like, screw it. And the PCRA recommends a solution to this thinking style is to help the offender develop such skills as patience, tolerance, and emotional control. The second one that was specific to Ryan was cognitive indolence. And that's the tendency to take shortcuts and look for the easy way around problems. And it said that such individuals are often enmeshed in controversy because their shortcuts invariably get them into trouble with those to whom they are accountable: supervisors, parents, spouses, probation officers. Those with this thinking style are frequently described as lazy, unmotivated, and irresponsible, lazy thinking. So this made complete sense to me, because the whole time I'm thinking, how irresponsible, how lazy are you that you can't fill out a freaking monthly supervision report and mail it in? Especially, or even just sitting down at your computer in the privacy of your own home and filling it out and pushing enter. Or how hard is it on your way home to pull over, do a drug test, and then keep going? You know, it's common sense for you and me, but so for me to read this, I got it. I'm like, okay, that makes sense. And then this last one really hit home, and it's the discontinuity. The propensity to lose sight of one's goals and to be easily sidetracked by environmental events. Respondents who elevate on this scale often come across as fragmented, flighty, and unpredictable. Discontinuity is the most difficult of the 8 thinking styles to confront because the individual is often oblivious to the inconsistency evident in his or her own thinking. Training and goal setting can be helpful in combating this thinking style. So this to me, then I kind of felt bad. So I'm like, okay, so Ryan knew that his job was important and that's what he was focusing on, but he didn't understand or see the whole picture. He, just like I said, he was fragmented, unpredictable. He didn't realize that he had this whole goal of probation and it was all these little different facets that he needed to work on. It wasn't just employment. So yes, he probably was doing the very best he's done in his whole life, but he had forgotten the whole goal and just focused on this one area. And so I'm thinking at this point, after reading all this, what do I do with this new information? I needed to, obviously I have a new appreciation for why he was behaving the way he was, and I was glad it wasn't a reflection on me. I had to come up with a new and unique and creative way to supervise Ryan so that he didn't fall back into that same trap again. Because he tends to get lazy and sidetracked, he needed an environment where he felt in charge and empowered. And because he ignores responsible action and has a history of failing to report, I want him to be able to come to the court where he's reporting but doesn't really know he's reporting. He needs some kind of cognitive behavioral therapy program where he can address these thinking errors that we just went over, but not the usual type of program where he's in a lecture environment, because he is overwhelmed with treatment, the typical type of treatment. So I thought about it and thought about it. And the state and county is way familiar with this, but we recently started doing MRT. And so I thought, you know what, that is perfect for him. And MRT is moral recognition therapy. It's a cognitive behavioral group that's actually ran by offenders. So he's in charge. He stands up. He does his own lesson, and he presents that lesson to the group. So not only is he learning from his own experience, but he's sharing that experience with others. Others are learning from him. He's setting goals, meeting those goals, and his peers are deciding whether or not he can move on to the next lesson. Several weeks into it, he called me and he's like, you know, Meriska, I love this. It's something that I've never experienced before. It's a type of therapy or treatment that he's never been exposed to, and he feels really empowered, and he's doing fabulous. So, to me, the PCRA has made a huge difference in how I communicate with my offenders, how I understand them differently, how I supervise them. It's unique. I feel completely lucky that we have this tool. I think all of us, you know, I think the key is learning how to use it, because it is so much information and it's so personalized. So we as officers just need to know exactly what to do with it. But I think that in the long run, we can, if we use it to its max, we can reduce recidivism by reducing the violations. And that's pretty much it. Mark, do you want to wrap up with questions?
I just think it was very valuable, Meriska, to have you juxtapose the two experiences, because it does show the value of using a risk assessment instrument and like using it, not filing it away, which is how we used to do things with the risk prediction index, right? It wasn't tied to case planning. People completed the risk prediction index because it was required, went in the file, and nobody paid any attention to the risk factors anymore. And so, very valuable. And a very practical application of what we've been talking about for the past couple hours in terms of risk assessment, criminogenic factors especially. You saw, just with this example, how the criminogenic factors and the criminal thinking styles that were exhibited by Ryan informed the way that Meriska supervised him, right? And I think one of the things that we're learning, especially working with federal problem-solving courts, reentry courts and post-conviction drug courts, is that this information is extremely helpful for prosecutors, defenders, and judges to have as well, right? Because if you're all sort of on the same page about what's happening with the person, right, and what types of treatment the person is receiving, and what that kind of treatment means, like what is moral recognition therapy, right? What does recognition mean? Right? I mean, it's a very interesting and evidence-based approach to cognitive behavioral treatment. And there are several, either Beth or Debbie referred to Thinking for a Change, right, which is produced by the National Institute of Corrections. And it's very commonly used. There's journaling, there's interactive journaling that's used. But the point is, we're talking about treatment matching, right, and responsivity, right? Is the person responsive to the treatment that is being given? Is the treatment being given with fidelity, right, as designed so that it's effective, right? And is it being matched to the criminogenic risk factors, the dynamic risk factors that the person has exhibited and the criminal thinking styles that they've exhibited? So it's, again, a much more continuous, systematic approach rather than just sort of throwing whatever treatment out there exists and seeing if it works. Not a good way to spend public money, right? And not a good way to help people change. Not a good way to work with communities. And so again, I think it's very valuable, not just for the probation officer to have this kind of information, but for all the stakeholders in the criminal justice system, correctional officers, halfway house people, judges, prosecutors, defenders. This has been the experience we've been having with these problem-solving courts that we've been working with in the federal system. So really valuable. It doesn't mean the judge needs to be the probation officer or the prosecutor needs to be the probation officer, but you do need to understand the language and in terms of what's happening with this person, right? Because that's what it is. It's a person, right? And this person's going to be back in the community, or they are back in the community, and we don't want them back in our system, right? So that's what this is all about. Questions, reactions, or anything before we wrap up? Everybody ready to get out of here? Rock and roll. Thank you.